Thank you very much, Joao. Good morning, good afternoon, and indeed good evening, distinguished experts and guests. My name is Christophe Bernasconi, Secretary General of the Hague Conference on Private National Law, or the HCCH as we like to call it in short these days. I'm very pleased to join you from the Permanent Bureau, our headquarters in The Hague, to open this year's edition of HCCH aBridged. I would like to begin by thanking our friends and colleagues who have made this event possible. First, the Bundesministerium der Justiz und für Verbraucherschutz, the Federal Ministry of Justice and Consumer Protection of Germany, for its generous sponsorship of this event. It truly would not have been possible without their support. Secondly, of course, to our friends at ASADIP, the American Association of Private International Law, to CARICOM, the Caribbean Community, and to the CCJ, the Caribbean Court of Justice, for sharing our vision and indeed our enthusiasm for this conference. This is the third HCCH aBridged event, an initiative launched in 2019 in an effort to explore innovation in cross-border litigation, civil procedure, and dispute resolution. The HCCH aBridged series provides a forum for experts and stakeholders from around the world to come together and discuss contemporary issues and solutions, always having inside one of our transnational litigation conventions. In 2019, we explored how the 1965 Service Convention operates in the area of electronic and information technology. In 2020, we celebrated the 50th anniversary of the 1970 Evidence Convention and looked at how technology made the convention as relevant as ever in its golden year. This year, the event is, of course, dedicated to the 2005 Choice of Court Convention and how it represents an important, innovative contribution to transnational litigation. The Choice of Court Convention is one of the somewhat newer HCCH conventions, in particular when we consider that it entered into force in October 2015. Despite this relatively short lifetime, it counts 32 parties across Latin America, Europe, and Asia. It is the first piece of the Judgments project, a project that began in the mid-1990s and which is still part of the core work of the HCCH with the recent adoption of the 2019 Judgments Convention, the second piece, and the ongoing work with the Working Group on Jurisdiction, which I'm confident will complete this modern normative litigation triptych in not too distant a future. The Choice of Court Convention is designed to complement other avenues for dispute resolution among commercial operators. The convention is centered around the concept of party autonomy, ensuring that parties to a contract can make an informed decision about their preferred method of dispute resolution. The importance of the Choice of Court Convention is only emphasized by the increasing establishment of international commercial courts around the world, designed specifically for the purpose of litigating cross-border disputes. These institutions ensure that appropriate expertise and practice are applied to these cases. And if the court is within a state to which the convention applies, litigants have legal certainty and predictability that when they enter a contract, which includes an exclusive choice of court clause, subject to well-defined restrictive exceptions, the chosen court will hear the dispute, no other court will hear the case, and the judgment of the chosen court will be recognized and enforced in other contracting parties. These international commercial courts are now located in business capitals across the world, including London, Singapore, Dubai, Paris, Shenzhen, Nur-Sultan, and Amsterdam. Last year, the London commercial courts had a record year, both in the number of cases that were decided, as well as the number of nationalities that were represented. Today, thus, is an opportunity to advance our understanding of the Convention and its huge potential impact for international trade and commerce. We are joined by an impressive cohort of experts who will share their experiences with the Convention and its role in the litigation market. The first panel will look at the policy argument for states joining the Convention, including its intersection with international commercial courts. I'm delighted to welcome a number of esteemed judges of these courts from different jurisdictions across the world to offer their insights. The second panel will explore the legal and practical arguments for joining the Convention, targeted towards practitioners whose clients are businesses. We again welcome speakers from across the world representing different legal traditions. I also look forward to hearing from my colleague, Dr. Ning Zhao, on the key findings from the questionnaire that was circulated earlier this year. But today's agenda begins, of course, with the distinguished Professor Trevor Hartley. Professor Hartley has not only been deeply involved in the negotiations of the Choice of Court Convention, together with Masato Dogauchi, he has of course also co-authored the excellent explanatory report on the Convention. I am delighted that he is joining us today. His reflections will provide a unique and most authoritative insight in the Convention's fundamentals and its operation, an insight that will also help us look into the future. Professor Hartley, thank you very much indeed for being with us today. The aBridged series is about sharing ideas and to bridge differences, traditions, and understandings of the law. I encourage all participants to engage as much as they can, to ask possibly difficult questions, and to continue the lively debate on the Convention. So, without further ado, I wish you all a wonderful and formative conference, and I hope that at the conclusion of the day, you are inspired by the potential future of cross-border litigation. Thank you very much, and back to you, Joao.